Welcome in, everyone. We are live with another episode of Level Up Law, where every Tuesday at noon here at South Carolina Legal Services, we are leveling up your legal knowledge on an area of law that we practice in. Today, we have a special Halloween episode at a special time, 11:30, with our guest, Andrea Stark, who is a senior attorney at the National Consumer Law Center, who just had a wonderful conference that they have every year, the Consumer Rights Litigation Conference, which I attended and had a wonderful time, learned a lot. And so we're really excited to have you with us today, Andrea, to talk about zombie second mortgages. Now, this is a really scary thing, so that's why we saved it for Halloween, but it's happening to a lot of homeowners these days, and Andrea's going to fill us in on how that all works, where it all came from, some of the things you can do, and hopefully not scare us to death on Halloween. So welcome in, Andrea. We're really so excited to have you here on Level Up Law.
Yeah, I'm very excited to be here. Thanks, Susan.
Okay. And before we get started, though, I do, as always, want to remind our viewers that this is not legal advice. It's just general information for the public, but it's really important information, and so we're really excited to be getting it out there for you today. Andrea is able to answer some questions if anyone has them and if time allows, so do put those in the question or chat box, and we'll take a look at those as we go along. So thanks for being with us, Andrea. Take it away.
All right. So before we start, I did put a link to this webinar in an email to a couple different listservs, and I put my link in that email. So if you accessed us through my presenter link, that's fine, but in the chat there is a link where you can register and come back in, or you can just stay muted and with your camera off, and that's fine too. So right. Sorry about that.
Thank you so much for pointing that out. I meant to do that, and
that's fine. That's fine. So,
but we're happy to have everybody here. So
yes, you can
thanks
stay.
For joining us, everyone.
Yes, thank you, thank you. Okay, so happy Halloween. We're going to talk about something very scary on Halloween, like Susan said, zombie second mortgages. And if you don't know what they are, well, you're going to find out during this webinar. I want to point out a few resources we have here. If you go to the NCLC website, you have a few resources here. We have an article, 12 ways to fight foreclosure of zombie second mortgages, fighting zombie second mortgages, a 2-pager with some resources, and both of those have links to our chapter in the Home Foreclosures Manual. If you're familiar with NCLC, you know that we have a series of manuals to help practitioners practice consumer law. One of them is Home Foreclosures. We have a new chapter in there just on second mortgages, and there are some links to that chapter in these resources, and I would recommend you check that out if you subscribe to our manuals and have access to them. So what you'll learn today, you're going to learn what is a zombie second mortgage. You're going to learn what's the current problem with zombie second mortgages and tools to help clients facing zombie second mortgages. So what is the problem here? The problem is a lot of advocates are now seeing clients coming in with these second mortgages that have been dormant for many years. They haven't heard from the servicer or the creditor for many years, and now these second mortgages are rearing their heads, and the debt collectors or loan servicers are trying to collect on these second mortgages and threatening foreclosure, or actually filing a foreclosure and threatening to take away the borrower's home. So this is coming out of the blue. There's been no real notice. There's been no real communication for years. And so we're hearing across the country that advocates are seeing more and more clients coming through the door with these second mortgages that are trying to collect now out of the blue. And they're asking for a lot of money. I mean, you see this guy here, this zombie, with a pile of cash because he wants your money. He wants your client's money for these zombie second mortgages, and not just the principal, but interest and fees and penalties. So how did this start? How did this problem start? We go back to around the early 2000s, and there was a lot of predatory lending, a lot of subprime lending, a lot of mortgage brokers who wanted to just get people in homes and walk away and didn't care how they got people into homes. A lot of lenders willing to give loans without really determining if the borrower could afford that loan. And so there were these loans called 80-20 loans, and 80-20 loans were when, in a typical traditional mortgage, a borrower puts 20% down, like a down payment of 20% of the purchase price in cash as a down payment. And then they pay the 80% through a mortgage. They get a mortgage to pay that remaining 80%. Well, these 80-20 loans came into play when people didn't have the 20% down. And so lenders, mortgage brokers kind of fabricated these two loans, one for 80% of the purchase price of the property and one for 20%. So that 20% down payment now became another loan. And so there were actually two loans on the property. And a lot of borrowers didn't understand that, didn't realize that they were getting two loans. They thought they were getting into a property, no money down, with really good rates. And initially, the rates on the first mortgage would be affordable, but those rates adjusted very quickly and became unaffordable. And the second mortgage rates, these zombie second mortgage rates, were very high, like around 10%, and would jump or adjust to maybe 12, 13% just after a few months or a year. And so there are very high interest rates that adjusted. There were payments there were penalties if you tried to pay off the loan early. There might have been a large balloon payment at the end of these loans to make it more affordable in the meantime. And there were just a lot of unfavorable terms that made them very unsustainable and unaffordable. And borrowers quickly fell behind on these second mortgages. And so around this time, the mid-2000s, there was the housing crash, the Great Recession, and the value of homes just plummeted. And so homes were underwater, and that means that the value of the home was much less than the mortgages on the home. So if you had a home worth $90,000 and a first mortgage of $100,000 and a second of $50,000, then that property's underwater because there's not enough value to sustain those mortgages. And so the second mortgages wouldn't foreclose. They knew that if they foreclosed, they would have to pay off that first mortgage first. And so if they threatened foreclosure, or if they filed foreclosure, whatever they got from the proceeds of the sale, they have to pay off that first lien first. So they'd have to pay that $100,000. And if they only got $90,000 for the sale of the house, that would all go to the first loan. And so they would get nothing. So they knew they would get nothing. And so they stopped collecting. They charged off these loans, which is just kind of an accounting procedure, and sold them. A lot of them sold these loans for pennies on the dollar and stopped all communicating with borrowers. No mortgage statements, no notices, and no calls, and just kind of went silent. And a lot of these borrowers thought, because they weren't getting a monthly bill, that the second mortgage was taken care of. A lot of them did fall behind on their first mortgage and were able to get modifications on the first mortgage to get back on track. And they thought the second would be included in that, and that they would be able to get back on track, a fresh start. Many of these borrowers have been paying those first mortgages for 10 years or more. They're current on their first mortgage. They have significant equity in their properties. And they thought the second mortgage either had been taken care of with a modification, or maybe they had filed bankruptcy during that time to save their home. And so they were thinking that the second mortgage was taken care of in the bankruptcy. And there were a lot of government relief programs during that time, some that actually waived the second mortgage and discharged the second mortgage. And so some borrowers thought that maybe they had been the beneficiary of one of those programs. So common characteristics of these loans were that they were underwater for years, they had been charged off, there was no communication from the servicer to the borrower about these loans, and some of these loans were sold to debt buyers for pennies on the dollar. And why are they rearing their heads now? Why are these zombies coming back from the dead now? Well, as we know, housing prices have escalated quite a bit in the last 3 or 4 years, and people have equity. So the rise in housing prices, that $90,000 valued home might now be $250,000. So there's significant equity. If the loans on the property are 150, the value is 250, there's 100,000 in equity now. And so the second mortgage knows, hey, if I foreclose, I'm going to get paid because I'll pay the 100 and I'll take the 50 that's owed to me, and everything will be great. Plus I'll take money for interest and fees and penalties. So I'm going to come out now and I'm going to threaten foreclosure, see if they start paying again. And if they don't pay me, I'm going to foreclose because I know I can get my money. So that's the zombie second mortgage. That's why they're coming out now. And there are a lot of debt buyers who bought these mortgages, and they're very aggressive with trying to collect on them. They don't really negotiate very well. They don't really provide loan modifications for borrowers. So it's very tricky for borrowers who thought they were current on their mortgage, thought they had finally gained some equity in their property. They have been struggling and doing what they needed to do to stay current, and now all of a sudden their homes are at risk of foreclosure and they're at risk of losing their home. And they're losing their homes not just for the principal that they borrowed, but now all this past due interest, interest on interest, fees that have accumulated over this 10+ period of time, years. And so what has happened in these 10 or so years? No notices, no periodic statements, no communication. So it really is out of the blue. It's a shocking, traumatic surprise for homeowners to now be facing foreclosure of their home. So after they struggled to keep their homes during the Great Recession and then during the COVID pandemic, and now they're being hit by these second mortgages saying, hey, you owe us tens of thousands, hundreds of thousands of dollars. And if you don't pay it, we're going to foreclose on your home. So who is being affected by this? The CFPB, the Consumer Financial Protection Bureau, has collected quite a few complaints about zombie second mortgages. And some of the themes that they've seen are that borrowers received a foreclosure or a collection notice when they were current on their first mortgage, and they thought the second mortgage had either been charged off, and it probably had been charged off, but a charge off is more of an accounting term. It doesn't mean they don't owe the debt. So some borrowers thought, hey, if it's charged off, I don't owe it anymore, but it doesn't work that way. You still owe the debt. They thought it might have been discharged in bankruptcy or part of a loan mod. And so a lot of borrowers just didn't realize the second was still out there. And some of them tried to get in touch with their second mortgage holder to make repayments, to start paying again, or maybe pay it through bankruptcy, but they just couldn't contact that second mortgage holder. As you can imagine, these loans have been sold over and over, the servicing has transferred over and over, and so it's really hard to find out who owns the loan now, who is the servicer now, especially with no communications. And the CFPB also has heard complaints about very aggressive collection tactics, where borrowers are approached in person to pay these loans, that they were told they face imminent foreclosure if they don't pay all the interest and junk fees that have accumulated. And they were pressured to accept unreasonable loan modification options, either a very short repayment plan or a high interest loan modification, something that really is not sustainable, but in their desperation to save their home, they entered into that. The creditors are also threatening negative credit reporting. I mean, these debts are so old, they shouldn't be reported on the credit report, but some of these aggressive debt buyers are saying we're going to start reporting you past due, and that's going to affect borrowers' abilities to get potentially find employment or find a rental property if they are foreclosed on. And so that's a real threat for borrowers. And so sometimes they enter into these deals that really are not sustainable or affordable. And who are the communities that are affected most? Well, we see that Black and Brown communities are disparately impacted. They were the communities who were targeted in the early 2000s with these predatory subprime loans. And so now these same loans are coming back to haunt them. We also see older adults are affected. It's been years since they've taken out that second mortgage. They've been current on their first mortgage. They have substantial equity, but they also are on a fixed income. And so trying to catch up and pay all of the amounts alleged owed is going to be very difficult, and they're at a high risk of losing their homes. So how can you help these borrowers? You can file a complaint with the CFPB. As you can see, they're really watching these and paying attention. We are trying to get them to act on this. They have done some work around zombie seconds. This year in April, there was a field hearing in Brooklyn, New York on zombie second mortgages that the CFPB put on, and some of us were able to testify at that hearing. And they have issued guidance on the time bar debt aspect of zombie second mortgages, and we'll talk about that in a little bit. And so the CFPB has taken notice of these, and so the more complaints they receive, I'm hoping that the more they will do to help borrowers with these types of mortgages. You can also file complaints with your state attorney general's office or your state's Bureau of Consumer Credit Protection or the Better Business Bureau. Anything you can do to get the word out that these debt buyers or servicers are trying to collect on these mortgages after years of being silent. And there are federal statutory protections available. So let me just take a sip of water. And we'll go through what legal options you might have for your clients. So there are federal notice requirements that these servicers and lenders should be following. Under the Truth in Lending Act, or TILA, there is a transfer of ownership notice that should go out every time the ownership of this loan, of a loan, is transferred. There's also transfer of servicing. So every time the servicer changes and a new servicer comes into play for this loan, there should be a notice under the Real Estate Settlement Procedures Act, or RESPA. And there should be periodic statements. Every month, the borrower should receive a statement about how much is owed under TILA, and we'll talk about these. And so the notice of transfer of ownership under TILA, so purchasers or assignees of a mortgage have to deliver notice to the borrower within 30 days of either a sale, transfer, or assignment of the loan. And that notice has to include the date that it was transferred or sold, where the transfer is recorded, who to contact on behalf of the creditor, and any other relevant information. So this is a really important notice for people to know who owns their loan, because if you know who owns the loan, then you can look up if there are any relief options available, any loss mitigation options available, what might be possible for this homeowner. There's also the notice of servicing transfer under RESPA. So RESPA, if the servicing transfers, the prior servicer has to do a goodbye letter within 15 days before the transfer. So before the transfer, they have to say, we're transferring the servicing of your mortgage to XYZ Servicing. And then XYZ Servicing has to send a hello letter saying, hey, we're XYZ Servicing, send payments to this address, we're your new servicer within 15 days after receiving servicing of that loan. And so this is really important as well, because as we know, borrowers pay their mortgage payment to the servicer. So if they're able to get back on track and try and negotiate some type of repayment plan or loss mitigation, that's going to be with the servicer. So they need to know who the loan servicer is. So what can you get for your client for these violations of TILA and RESPA? Well, you can get actual damages, monetary damages if there are any. You can get statutory damages TILA up to $4,000, RESPA up to $2,000 if there's a pattern in practice of non-compliance. So if you know of other clients with the same servicer doing the same conduct, failing to send goodbye or hello letters for transfer of servicing, that can constitute a pattern in practice of non-compliance. And so you can get to up to $2,000 for your client. You can also get attorney's fees and costs. So there are some limitations. There's a 1-year statute of limitations for TILA, and the liability is for any creditor or assignee, so it's not for servicers. And RESPA is limited to servicers, and there's a 3-year statute of limitations, just to be aware of those. So I mentioned earlier that servicers and lenders should be sending out periodic statements, which are monthly mortgage statements to borrowers. And this is under the Truth in Lending Act, and for closed-end mortgages, which is going to be the majority of these mortgages, they must send a statement that includes a breakdown of the amount due and the breakdown of past payments since the last statement. And there are other requirements of information they must put in that statement as well. I provided the citation for you. But those are the two main things, so that the borrower can know how much they owe and potentially challenge that amount, and a breakdown of past payments. So if, for example, a lender is claiming on that $50,000 second loan that the borrower owes $50,000, but the borrower knows that they've made some payments at the beginning of the loan, so it should be less than the $50,000 in principal at least. These statements are supposed to provide the last statement, the last payments made, an accounting of amounts owed, and it should provide information about those last payments and how they were applied and credited. And a lot of these debt buyers just don't have that information, and so they're claiming the full $50,000 principal is owed. So it's important to have these periodic statements so that borrowers know how much is owed, and they can challenge how much is owed if they think it's inaccurate. And so there is an exception for sending periodic statements for what we call charged off loans. And like I said, that's kind of an accounting practice. They charge off the loan primarily for tax purposes. It doesn't mean it's forgiven or waived or discharged. It's just charged off. So if the lender charged off the loan, they don't have to send statements if they did two things. If they don't charge any fees or interest for that period of time when they're not sending statements, and they send the notice, a notice to the borrower within 30 days of that charge off, saying we're charging off the loan and we're not going to charge you interest and fees. So I've only heard of potentially one borrower receiving that actual notice. So I don't think many lenders were sending out those notices, so I don't think many lenders are going to be privy to this exception. They're not going to have the exception, so they're still going to be obligated to send periodic statements. So for a charged off loan, though, and periodic statements, if the interest or fees are charged to the account during that charge off period, or at the end of that, if the lender wants to start charging interest again, they need to send monthly statements. So you charge interest, you send monthly statements. But if all of a sudden they decide, okay, we want to charge interest again, we're going to start sending monthly statements, they can't retroactively charge interest. If they were part of that exception for a period of 5 to 10 years and they weren't sending statements and they told the borrower they're not going to charge interest, well, they can't go back now and retroactively charge for interest. So it's a big deal to look at what interest the lender is claiming is due. And there is an argument that if they weren't sending monthly statements, it's an unfair practice to charge interest. It may not technically be a violation of TILA to do that, but it could be a violation under your Unfair and Deceptive Practices Act, your state law, and an unfair practice to not send any statements, not have any communication for 10 plus years, and then out of the blue come and say, oh, you owe the principal plus all of this interest. I would make the argument that that is an unfair and deceptive practice. So some of these zombie seconds are HELOCs, or home equity lines of credit. They also have a periodic statement rule under TILA, but they're not subject to some of the protections under RESPA or Regulation X. I'm not going to really get into that now, but just to know that they are subject, they have their own periodic statement rule, and I put the citations here for you as well. So limitations with the periodic statement rule, that requirement for closed-end loans only came into effect in January of 2014, and that if you do have a loan that met the exception for the charge-off loans and they weren't supposed to charge the retroactive interest, that rule only came into effect in 2017. So just keep mind of the limitations for these rules. What relief can you get for violation? You can get actual damages again. That might include the charges and interest that could have been avoided if the borrower had received statements and they could pay those statements and they knew how much to pay and they would have paid those statements. It could be the charges and interest that would have been avoided if those monthly statements had been provided. And also claims for emotional distress. So no monthly statements for 10 years, and then out of the blue, you get a statement for double what you originally took out, and all of a sudden your home is at risk of foreclosure. So actual damages for TILA and RESPA do include emotional distress damages. Also attorney's fees and costs, and keep in mind there's a 1-year statute of limitation. And there's also a caveat. I put a note and a citation down here. I'm not going to really go into it, but there's also exceptions for the periodic statement rule if your borrower is in a bankruptcy. So just keep mind of that. I'll pause for just a second and see if there are any questions. If not, I can keep going.
There's no questions at the moment, but I do have a quick one. Is there a particular length of time, or is it kind of on a case-by-case basis that makes the mortgage turn into a zombie mortgage like we're talking about?
Yeah, no, that's a really good question. There is no particular prescribed amount of time, but I do think the longer it's dormant, the better your facts. I would say maybe 5+ years without hearing from the servicer is quite a long time, or from the lender is quite a long time. And having that loan be dormant for 5 or more years, I would think that would be a zombie. I mean, if you talk about 3 years, that's still a good chunk of time, but it's not, that those facts aren't as strong. So I guess it would also depend on what are the effects of not receiving monthly statements or any communications from the servicer or lender for that period of time. So it is very fact specific. There's no definite amount of time.
And I do want to remind our viewers that Andrea is willing to take questions, so be sure and put those in the chat if you have any of them. All right, thanks.
Yeah. So getting information about the loan. This is really important because these borrowers haven't heard from these lenders or servicers in many years, and these loans have been sold over and over. The servicing is transferred over and over, and so I'm sure the accounting of these loans has not been accurate because it's changed hands so many times, and by the time it gets to a debt buyer, potentially all they have is maybe the loan number and amount and an amount alleged owed, and they don't have any records. So how are you going to try and get information about the loan? Those of you who do foreclosure defense and mortgage servicing work, you know well the qualified written request under RESPA. And the qualified written request is something the borrower can do. You can help the borrower write this request to get information about the loan and about the account history, about the amounts alleged owed. And if there's an error with the billing or accounting, they can allege an error and ask that it be fixed. And it provides an additional legal claim under RESPA if they don't comply with the statute and regulation. And so what constitutes a QWR? There are two different types of QWRs, or qualified written requests. One is a request for information, and we call that an RFI, and another is a notice of error, we call that an NOE, and those are under the regulations of RESPA. So they're under Reg X, an RFI and an NOE. And these letters have to be sent to the servicer's designated address for them to count as an RFI or an NOE, and for the borrower to be entitled to relief if the servicer doesn't comply with the RFI or NOE. So the servicer should have the address on their website for where to send QWR, RFI, or NOE. And if your client is getting statements again, it should be on the periodic statement, the monthly statement. And so definitely you have to send to that address for it to count under the statute or regulation. And you have to include certain information like the borrower's name and contact information, information about the mortgage account, whatever the borrower alleges was an error. You have to explain what the error was, and that the borrower would like that investigated and fixed. And if it's being sent by you, if you're writing the letter and sending it, an authorization form from the borrower saying, I authorize my attorney, my advocate, or housing counselor to send this letter to you and request this information or allege these errors. Generally, we would have we would help the borrower write the letter and then have the borrower send the letter, certified mail, return receipt requested. So now they've paid for certified mail, which could be an actual damage if they continue to have to send these. And it also makes them part of the process and engages them in the process. So there are specific deadlines a servicer has to account for with these RFIs and NOEs. So they have to acknowledge receipt, send a letter to the borrower saying, yes, we received this within 5 business days of receipt of the letter. And then they have to conduct a reasonable investigation and respond within 30 business days. So this is really important. This isn't just a letter you send alleging errors, requesting information, and if you get an answer, great. No, the servicer has to provide a response within these time limits. And if they don't, they're violating the regulation. And so request for information, you can ask any information that relates to the servicing of the mortgage loan. So that's really expansive. So you can ask for an accounting of the amounts alleged owed, the application of payments, an accounting of payments made, the loan history. You can ask for, we'll go over some of the things you might want to ask for these zombie second mortgages. And the servicer has to provide this information or explain why they're not providing it. And they have to provide a contact person for the borrower to be able to get in touch with to discuss this and understand what information is being provided, what information is not being provided, and why it's not being provided. And so for zombie seconds, what might you want to request? Well, you definitely can ask who owns my loan and who is the servicer of the loan. And when did they become the owner and servicer of the loan? You can ask for an itemized amount of what's owed. You can ask for a payoff statement, loan documents. You can ask if there were any prior loan modifications, an account transaction history that shows all the payments that were made, all the payments that were paid out by the servicer to third parties, like for taxes or insurance or property management fees. You can ask for all transfers of ownership and transfer of servicing notices. And chances are they're not going to have these because they just weren't sending them out. And that's another violation right there. You can ask for all the monthly statements that they've sent to the borrower. Chances are they're not going to have these. I have heard, though, that they come up with monthly statements. Internally, they may create them or have them, but make sure if you take this case further that you really investigate whether these were sent to the borrower and ask for proof that these were sent to the borrower, because sometimes they'll have them internally, but they were never sent to the borrower. So that's just something to keep in mind as well. And you can ask, okay, you're the servicer, what loss mitigation or options are available for my client, or the borrower can ask that. And make sure that the request involves servicing activity. So that's the parameter. Anything that a servicer would do or handle, you can ask about. And how many of these do you do? Well, you can do one, and if you get an appropriate answer, that's great. But if you don't, then you can do another one, and then you can do another one. And yes, that takes time, but it also sets up a case, a pattern and practice of violation of the regulation, and your client would be entitled to some relief for those violations. And a notice of error is very similar, but if you get this information and you see that there's an error with the billing or accounting of this loan or any other servicing item, you can allege that error. And that could be wrong amounts charged, excessive amounts charged, inaccurate amounts, retroactive interest that they're not allowed to charge. You can allege an error in a letter to the servicer. And the servicer has to correct that error. They have to do an investigation, reasonable investigation, and either correct the error or provide a notice saying what they found and that they think this is not an error and why they think this is not an error. So they have to give an explanation. Either they fix it or they give an explanation. So they're required to do that. And if they don't do that, and if they don't comply with the request for information provisions, again, actual damages, the client's entitled to actual damages. Again, statutory damage that's up to $2,000 if there's a pattern and practice of non-compliance. So you're probably not going to want to bring a lawsuit after one violation. But if you have 2, 3, 4 letters and they're failing to respond to those letters appropriately, then you have a pattern and practice of non-compliance. You also get attorney's fees and costs if you're successful in the action. And the statute of limitations is 3 years for these. So what else can you do for your borrowers facing zombie second mortgages? You can look at bankruptcy. Definitely consult with a bankruptcy attorney. See if this might be an option for your client to pay back the amounts alleged owed, but also to challenge those amounts owed in the bankruptcy. You can do that in the context of a bankruptcy. And if the borrower doesn't want the home anymore and just wants to get out, if it maybe it is underwater and they would be facing a deficiency if it was foreclosed on, they can surrender the house and discharge the debt in a bankruptcy. But if they surrendered the house, then that would be it. They would have to leave the home. And so if that's one of their options, then bankruptcy might be a good option for them. Also, check their credit report. Make sure these mortgages should not be reporting because they are so old. But if they are reporting, make sure it's accurate. Whatever is being reported on there, make sure it's within the time frame allowed and that it's accurate. If they're claiming $100,000 is past due on a $50,000 loan, that's probably not accurate. And so maybe you do your RFI and get the information and prove that it's not accurate, and then you file a dispute with the credit reporting agencies. You can connect with an attorney who does Fair Credit Reporting Act cases to help you with that. And the National Association of Consumer Advocates, or NACA, has a find an attorney option, and you could find an attorney that does FCRA work or consumer bankruptcy work, and consult with them and see what other options you might have for your client. There are other considerations, whether you're in a judicial or non-judicial foreclosure state. So in a judicial foreclosure state, you're going to get some warning, you're going to get some time potentially, hopefully, that this has now gone to foreclosure, and second mortgage servicer and lender have filed for foreclosure. And so in the judicial context, you're going to have a court process, whereas in the non-judicial foreclosure state, you may have to go to court to stop the sale. You may have to do an affirmative action to stop the sale if you believe that it's a wrongful foreclosure. So just being aware of that. Time bar debt. So I mentioned earlier that the CFPB came out with an advisory opinion that if the zombie second mortgage debt is time barred, meaning it's beyond the statute of limitations of when it can be collected, it can be a violation of the Fair Debt Collection Practices Act to threaten foreclosure or foreclose on that debt. And so if you're in a state like New York that has a 6-year statute of limitation, this can be very helpful. Other states have a much longer statute of limitation, so it's not as helpful, but it can be a defense to a foreclosure, or it could be an affirmative claim. And then also check and see if your homeowners assistance fund in your state still has money available, still accepting applications, because you may be able to use some of that money to help pay the second mortgage and bring that current again. And I will just highlight, this is our manual, home foreclosures manual on our digital library. We have a new chapter in here, like I said, on zombie second mortgages. And we also have, if you're unsure of your state foreclosure laws, there's an appendix here that talks about the different foreclosure laws in the different states. So that's what I have. If we have any questions, I'm happy to answer them.
Awesome. Thank you so much, Andrea. We do have one question. When does the statute of limitations begin to run on a 1024.33 or 1026.7 violation?
Okay, so the 1020, so that's RESPA and TILA. So RESPA is the 1024.33 or those QWRs we're talking about. And the statute of limitation is at the time of the violation. So say you send a notice of error and they don't investigate, they don't do a reasonable investigation, and they just come back with their answer and they say, you know, there's no error. And so that's the time when it starts to run, when there's at the time of the actual violation is when the statute of limitations begins to run. Okay.
It looks like that's all the questions for now, but I'll check it one more time before we sign off. Andrea, I do want to thank you so much for taking time out of the important work that you are doing there at the National Consumer Law Center to join us for this special Halloween episode. It's been really great, really thorough. That's probably why there aren't many questions. A really thorough explanation of the whole zombie second mortgage process. Very simple and understandable. So we always appreciate that here on Level Up Law. And so hopefully our viewers will be a little less scared when they suddenly hear from a mortgage debt collector that they have not heard from in many, many years. And I do want to remind everyone, if you are in South Carolina, you can apply for assistance with this or any other mortgage and foreclosure issues by contacting South Carolina Legal Services, and we'll have all that information in the description box below for the replay. And I do want to encourage the attorneys out there. The digital library at NCLC is wonderful. It's like a Bible for most of us who are practicing consumer law. It's the go-to series of treatises for what we do, and I encourage. And the digital version is so easy; it's just right there at your fingertips at any moment. And so I find that we really use it a lot here at South Carolina Legal Services. I encourage anybody who doesn't have it to get it. So anyway, let's just check for any other questions, and I don't see any. And again, Andrea, thank you so much for being with us today. And I want to thank our producer, Kenneth Elliott, who is always there in the background making sure everything's working for us. Thanks, Kenneth. And thank you to our audience. We really appreciate when you join us live here on Level Up Law. We had a great audience today. I'm sure we'll have many more on the replay, and we really do appreciate that we have an audience that appreciates what we do here on Level Up Law. So again, thanks, Andrea. Thanks, everybody, for joining us. That concludes today's episode. But be sure to tune in next Tuesday for another live episode of Level Up Law. Thanks, everybody.
Thank you.